All right, how's everybody doing? This is Mr. Huff. We're going to be talking about Lesson 211 today, Constitution Change and Formal Amendment. Essentially, we're going to be looking at how is it that the Constitution changes over time? What's the process by which that changes, and what are the consequences of that? Um, the Articles of Confederation were overhauled, rewritten after only 8 years, but the Constitution, which was the document that replaced it, has still been going strong for well over 200 years. And so, the question is, why is that the case? And one of the reasons is because we have this process of making what we call amendments, changes to the Constitution, ways that we can kind of address issues and make just some important changes so that the Constitution can continue on. We're going to look at those changes, those amendments in this lesson. I want to point out here, guys, that at the bottom of this, just like on all of these lessons, there are these key words. I would really encourage you to take a look at those keywords, put those into your notes, and as you're doing your reading, make sure that you get a definition of each of those things. Make sure you know what each of those things are, what it's all about. Our keywords for this lesson: Bill of Rights, Cabinet, Electoral College, Executive Agreement, Formal Amendment, Marbury versus Madison, and Senatorial Courtesy. Now, in what I'm going to talk about today, I'm going to talk about a lot of these things, but I'm not going to talk about all of them. Remember that you have the responsibility of going through and doing the reading apart from, just this module. Okay, so be sure that you're doing that. All right, so let's go ahead and get started with this. Hold on, I'm having some issues with my computer. Okay, there we go. All right, so the formal amendment process. So how is it that the Constitution can be changed? Well, there's a couple of things that have to happen. There has to be a proposal of amendment, right? Someone has to suggest a change be made to the Constitution, and then there has to be an approval of that change. We call an approval, we call that ratifying. That's a really good term. We talked about that before. Okay, in order to make an amendment to the Constitution, the proposal has to be made, and there's one of two ways that the proposal of amendment can be made. The first way is it could be made by 2/3 vote of both houses of Congress. Okay, remember, we have a bicameral legislature in the United States. There is a House of Representatives and a Senate. So in order to propose an amendment, one of the ways that can happen is if 2/3 of both the House of Representatives and the Senate propose an amendment. The other way that an amendment can be proposed is if 2/3 of the states propose an amendment. So 2/3 of the states can propose an amendment, and once an amendment is proposed, it then goes into the ratification process. Remember, the word ratify means to approve. Okay. In order to ratify an amendment, whether it was proposed by the legislature, right, the House of the Senate, or whether it was proposed by the states, in order for an amendment to the Constitution to be ratified, it has to be approved or ratified by 3/4 of states. So 3/4 of the states have to ratify an amendment. All right, and that's a very difficult process. There are amendments that some amendments have taken as many as 200 years to be approved. In fact, the 27th Amendment to the Constitution was proposed in the 1790s and wasn't approved until the 1990s. So it was over 200 years later that ratification process, finally completed. And like I said, it's difficult to get that much support for proposal and that much support for ratification. So because of that, only 27 times has the Constitution been amended. All right. But those amendments are really important. All right. There are things like extending the right to vote to women, or things like abolishing slavery. These are real significant issues that are solved with a constitutional amendment. Remember, I said there are 27 amendments. The first 10 amendments, so amendments 1 through 10, are a special group, and they're called the Bill of Rights. The Bill of Rights is the first 10 amendments to the Constitution. Okay, and we're going to talk through these amendments that make up the Bill of Rights here in just a second. But one thing to understand is that, remember that debate that we talked about between the Federalists and the Anti-Federalists when it comes to ratifying the Constitution, replacing the Articles of Confederation with the Constitution. One of the compromises that was made is that the Anti-Federalists agreed to support the Constitution if 10 amendments or 10 changes were made to the Constitution. Those are the first 10 amendments, and those make up what we call today the Bill of Rights. Okay? So let's walk through just briefly what these are. First Amendment, freedom of religion, speech, the press, the right of assembly, the right of petition, essentially the right to protest is what the First Amendment is about. The Second Amendment, the right to keep and bear arms. Third Amendment deals with an issue of housing of troops, and this comes out of the American Revolution when the British government forced American colonists to house troops in their homes. So now today that is something that the government cannot force you to allow troops to stay in your home. Fourth Amendment deals with searches and seizures, warrants, that sort of thing. Can the police just walk into your house and start looking for evidence of a crime? Well, not without a warrant because of the Fourth Amendment. The Fifth Amendment deals with rights in criminal cases. Sixth Amendment also deals with trial rights, deals with trial by jury and that sort of thing. The Seventh Amendment deals with rights in civil cases. Civil cases are different from criminal cases. Criminal cases are whenever a crime has been committed or is alleged to have been committed, murder or robbery or those kinds of things are criminal cases. Civil cases is when one person sues another. That's kind of a key difference, and we'll talk about that when we get into the judicial system a little bit. Okay. But the Seventh Amendment deals with rights in civil cases. The Eighth Amendment deals with bail, fines, deals with what's legal and not legal as far as punishment goes. It specifically bans something called cruel and unusual punishment, and there's a lot of debate over what exactly constitutes cruel and unusual punishment, but the Eighth Amendment makes that illegal. Okay, Ninth and Tenth Amendments are the ones that are most confusing, but in a lot of ways they're the most important. Okay, essentially what they say is that any power not specifically given to the federal government belongs to the state governments. Okay, and we say that again. Any power not specifically given to the federal government by the Constitution is given to the state governments. All right, so that's our first 10 amendments, the Bill of Rights. Okay, so we talked about this formal amendment process that's very, very complex, very difficult to do, and those are done for really big, important things, but that doesn't mean that everything that the government does or every change the government makes has to go through that process, because we have a lot of things that don't rise to the level of being a constitutional amendment, just basic laws and acts of Congress or acts of the president, that sort of thing. And so think about the Constitution as kind of being the big picture of how the government operates, and laws and court rulings and actions of the president, that sort of thing, all are kind of more day-to-day, more smaller issues that are dealt with, if you want to look at it that way. Okay, but that means that the Constitution is open to interpretation, right? And who is it that gets to interpret the Constitution? Who is it that gets to decide what the Constitution means on this particular issue or that particular issue? Well, a lot of that was settled in 1803, okay, with something called judicial review. And I won't get into a lot of it because it's kind of a complex story, but it's an interesting story if you want to read about it. But there was a court case in 1803, and the court case was called Marbury versus Madison. Okay, so this guy named William Marbury was suing James Madison. It went all the way to the Supreme Court, and the Supreme Court was led at the time by the guy who was the Chief Justice of the Supreme Court, really important man named John Marshall. And John Marshall was probably the most influential, most important Supreme Court Chief Justice. But John Marshall ruled in this case essentially that the Supreme Court had the right to rule an act of Congress unconstitutional. It had the right to say that an act of Congress was not legal. Okay, we call that judicial review. Okay, and it essentially, John Marshall said, well, it's the Supreme Court that decides if an act of Congress is constitutional, if an act of the president is constitutional, if an act of a lower court is constitutional. So that we call that judicial review. Okay, I'll let you, you can watch this video and kind of go through this on your own. But I'm going to skip straight to the quick check. Okay. So we're going to go through. We're going to talk about these questions now. Like I said at the beginning, remember, a lot of this is stuff we talked about here in the last 10 minutes or so. But there's I can't talk about everything. There's a lot of this that you're going to have to read about that. So be sure that as you're going through these modules, you're doing that reading that goes along with it. Otherwise, you're not going to get all the information you need to do well on the quizzes or do well on the the tests, that sort of thing. Okay. Which of the following is true about the formal amendment process for the Constitution? Okay. Any citizen can propose an amendment. Only Congress may propose an amendment. Both houses of Congress must pass a resolution to propose an amendment. The president can veto an amendment. Okay. So remember, it's both houses of Congress that have to propose an amendment. It also could be proposed by the states. Okay. Why was it a problem that Congress did not have the power to tax under the Articles of Confederation? This goes all the way back to a couple of sections ago. But if Congress didn't have the power to tax, how are they going to get money? Well, they could borrow money, and by borrowing money, that increased the debt. Okay. I do not think that the United States would come to an end if the court lost their power to declare an act of Congress void. I do think that the Union would be imperiled if we could not make that declaration as to the laws of the several states. Okay, so what is Justice Oliver Wendell Holmes saying here? I look at this last sentence. I do think that the Union would be imperiled or be in danger if we could not make that declaration as to the laws of the several states. So essentially what he's saying is, laws passed by state governments are so varied and numerous that the federal government should have no say over their constitutionality. Is he saying that Congress does not pass unconstitutional laws so that there's no need for the Supreme Court to review those laws? Is he saying that all state laws should be reviewed by the Supreme Court to keep federal system running? Or is he saying the Supreme Court needs to be able to settle disputes between the states and the federal government by reviewing the constitutionality of state laws? Okay, that's this last one. What constitutional principle prevents the tyranny that James Madison describes in the quotation below? Okay, the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, may justly be pronounced the very definition of tyranny. So he's talking about, is it a good thing for all these powers, legislative, executive, and judicial, all being in the hands of the same person or the same group of people? He says, no, that's the very definition of tyranny. So instead, those powers, according to James Madison, should be separated. Okay, so popular sovereignty, separation of powers, federalism, judicial review. Okay, so it's separation of powers. In the compound Republic of America, the power is first divided between two distinct governments. The different governments will control each other at the same time, but each will be controlled by itself. All right, again, by James Madison. And what is he talking about here? Well, it's kind of confusing, but he's talking about two distinct governments. The governments will control each other at the same time. Each will be controlled by itself. Well, let's look at the options. Popular sovereignty, checks and balances, federalism, judicial review. Okay, so which constitutional principle is Madison talking about here? Well, think about what federalism means. Federalism means that some powers are in the hands of the central government. Some powers are in the hands of the state government. So a kind of dividing up, who has that power. So the answer is federalism here. What are the reserved powers as outlined in the 10th Amendment? Remember, I said that was the one where that any power not given to the federal government by the Constitution belongs to state government. So which of these says that? All right. Powers that are not delegated to the federal government and therefore granted to the state as long as they are not prohibited by the Constitution. Power is granted to the Supreme Court to exercise judicial review. Powers delegated to the states and therefore that are not delegated to the states and therefore granted to the federal government as long as they are not prohibited by the Constitution. Powers granted to the president to veto bills passed by Congress. Okay, well, the reserve powers, remember, deals with the states and the federal government. Okay, so this B and D are out. I'll also point out to you A and C are the first and the third one here. Guys, these are exact opposites of each other. And oftentimes when you see multiple choice questions and two of the options are exact opposites of each other, almost always one of those is the correct answer. Okay? And so the reserve powers are powers that are not delegated to the federal government, but are, and therefore they are granted to the states. So it's this one. Okay? It therefore belongs to the courts to ascertain the meaning of any particular act proceeding from the legislative body. Again, look what he's saying. Alexander Hamilton is saying that it is up to the courts to determine the meaning of a law. So what is he talking about? What specific constitutional principle is Alexander Hamilton referring to in this quotation? The power to veto acts of Congress, the authority to interpret laws, the right to form a federal court system, the system of checks and balances. He's talking about ascertaining the meaning. Another way of saying that is interpret. So we're interpreting the laws. We, the General Assembly of Virginia, do enact that no man shall be compelled to frequent or support any religious worship, place, or ministry whatsoever, nor shall be enforced, restrained, molested, or burdened in his body or goods, nor shall otherwise suffer on account of his religious opinions or beliefs, but that all men shall be free to profess and by argument to maintain their opinions in matters of religion, and that the same shall in no way diminish, enlarge, or affect their civil capacities. That's a lot of words. It's very confusing. But what is it talking about? Well, in a big picture, it's saying that you have the freedom of religion. Okay, so the guarantee of religious liberty found in this proposed law is a sort of guarantee of individual rights that Anti-Federalists demanded to be added to the Constitution. Okay, the resulting listing of basic liberties in the Constitution is called, okay, the guarantee of individual rights that Anti-Federalists demanded be added to the Constitution. Remember, we talked about that. That's that group of 10 amendments that the Anti-Federalists wanted to be added to the Constitution in order for them to support the Constitution, and we call that the Bill of Rights. Okay? What compromise prevented Congress from challenging the migration or importation of such persons as any state now existing shall think proper to admit? And again, remember, we talked about this earlier, but it's the slave trade compromise. Okay, and again, about the 10th Amendment demonstrated constitutional provision for limiting government. Okay, the powers not delegated to the U.S. by the Constitution nor prohibited to the states are reserved to the states respectively or to the people. Again, anything that doesn't, any power not given to the federal government by the Constitution is given to states. All right, so it gives explicit powers to state governments. States and individuals have the powers and rights not claimed by the federal government in the Constitution. It defines the rights of the people. It prevents the federal government from intervening in individual affairs. Okay, so it's this one right here. Again, dealing with the fact that the federal government, any power not given to the federal government belongs to the states. Okay, so that's it, guys. Hope you have a wonderful day, and we'll talk to you later.